Welcome to the inaugural high school moot court in Ohio. I'm Stephanie Bucher with the Ohio Supreme Court's Office of Public Information. We're coming to you from the Thomas J. Moyer Ohio Judicial Center in Columbus, where more than 70 students from 13 high schools will be participating in today's event. Moot Court is a program of the Ohio Center for Law-Related Education that focuses on the appellate court process, an often misunderstood part of our judicial system. The 2014 Moot Court case, Charlie Charleston v. State of Ohio, centers on the Fourth Amendment, which is the right against illegal search and seizure, and a hypothetical stand-your-ground Ohio law. In this year's case, a high school student arrives at his parents' house at night and sees a stranger approaching as he gets out of his vehicle. As the stranger gets closer, the student begins to feel threatened, draws a gun, and shoots and kills the stranger. When police arrive, they search the student's car and discover incriminating material. The student is ultimately convicted of second-degree murder, and in his appeal argues he acted in self-defense and that police violated the Fourth Amendment in the search of his vehicle. Moot Court incorporates both written and oral argument components. The students have submitted their written briefs in which legal issues of the case have been presented. And prior to the competition today, the students' written briefs were reviewed and scored by a panel of volunteer attorneys. Today, 16 teams will present oral arguments for both sides of the case against other competing teams. A team consists of 2 student attorneys and a timekeeper. The written briefs are judged on a number of different components, including organization, grammar, analysis, and persuasiveness. Arguments are evaluated on the application of the law to the facts of the case. Now, by focusing on the applicability of constitutional law to current legal issues, Moot Court offers the students an opportunity to develop an understanding of the Constitution and the judicial system while strengthening their writing, speaking, and critical thinking skills. And if you would like some more information about this program or any other by the Ohio Center for Law-Related Education, you may visit their website at oclre.org. Now, let's watch as our students present their arguments in the Moot Court 2014 state competition.
Good afternoon. Welcome to the Court of Appeals. Case of Charleston versus State of Ohio, I believe. It's on today's docket. Appellant ready to proceed?
Yes, Your Honor.
Okay. And Appellee?
Yes, Your Honor.
Okay. Appellant, you're up.
May I proceed, Your Honor?
Yes.
Your Honors, before my time begins today, I would like to take the time to introduce my team. I'm Evan Nichols, my co-counsel is Melinda Baer, and we represent the appellant, Mr. Charlie Charleston. There are 2 questions before this court today. The first concerning whether the Fourth Amendment protects the data on an electronic tablet incident to a lawful arrest, which I will be delivering, and the second, which concerns whether Revised Code 2999-32 requires a pretrial evidentiary hearing, and whether this error can be deemed harmless, which Ms. Baer will be delivering. Moot Court rules grant the appellant a 5-minute rebuttal period, which I will be delivering if necessary. Mr. Chief Justice, may it please the court. Mr. Charleston was convicted of second-degree murder after a 2-week bench trial. Prior to his trial, Mr. Charleston moved to suppress the evidence unconstitutionally taken from his iPad after his arrest. This motion was later denied. Also prior to trial, Mr. Charleston moved to dismiss the charges against him under Ohio Revised Code 2999-32. This motion was denied without a pretrial evidentiary hearing. Mr. Charleston was only permitted to present his self-defense evidence as mitigating factors at sentencing. The facts of this case began on the stark and snowy night of December 15th, 2011, when Mr. Charleston returned home from a day of school, parked outside of his parents' house, got out of his car, and walked to his trunk to retrieve his backpack. At this point, a stranger wearing dark clothing and a ski mask, carrying a snow shovel, approached Mr. Charleston and shouted, "Hey, you." Alarmed, Mr. Charleston retrieved a gun from his trunk and warned the stranger to stay away or I will shoot. The stranger then slipped on the ice and flailed his arms. Mr. Charleston read the flailing of the arms as a sign that the stranger was going to attack him with the snow shovel. So he fired 2 shots into the stranger. Mr. Charleston then got back in his car and drove to his friend's house, where they called the police. After being told that the police had already arrived on the scene, Mr. Charleston drove back to his home, where the police interrogated him and placed him under arrest. After placing him under arrest and placing him in a police car, the police conducted a full search of Mr. Charleston's vehicle. Inside the vehicle, they found a gun sitting on the passenger side seat and an iPad located on the floorboard of the passenger side seat. The police picked up this iPad, opened it, and searched through its contents, finding a list of names which they characterize as a hit list. The decedent's name, Mr. Jacques Slater, was on this list. Mr. Charleston later was charged with first-degree murder. Your Honors, I have 3 points I'd like to make today. The first is that people have a greater expectation of privacy in their iPads than in cell phones. The second, therefore, extending this court's requirements from State v. Smith to electronic tablets would be logical. And 3, the 2 exceptions from the Smith case are absent today. The United States Supreme Court held in Katz v. United States that all warrantless searches are per se unreasonable, subject to only a few well-delineated exceptions. One of these exceptions is a search incident to a lawful arrest, the need for which derives from officer safety and the preservation of evidence. This court has ruled that electronic data requires special consideration because it's not a physical object in a closed container. The iPad is able to make calls, send text messages, and access private documents, emails, and calendars. People can even do their personal finances on their iPads. iPads in many ways can be used as a substitute for a laptop computer. The holding of electronic data is an important consideration that this court gave in State v. Smith. This court ruled that searches incident to lawful arrest don't extend to cell phones unless there is a need to protect officer safety and the preservation of evidence.
And isn't that alternative, the preservation of evidence, the issue in this matter?
Yes, Your Honor, it is. This court ruled that after a cell phone has been seized, the threat to destruction of evidence is gone because the police have gained control of the cell phone and nobody else can go in and delete the data that it may hold.
Can cell phones or iPads have information deleted when they're not in possession from far away via the internet?
Yes, these iPads would need to have internet access, though, so simply turning off the device would alleviate this problem completely.
Was the device on or off in this case?
When the police found this device, it was on, but they had every opportunity to turn it off. So extending the Smith requirements to iPads and electronic tablets is very logical. This court's major consideration was the amount of private data stored on cell phones and their ability to transmit this data, which makes them different than, say, a briefcase. iPads store even more data than cell phones, especially cell phones from 2009 when this court decided the Smith case. So therefore, people have an increased expectation of privacy in their iPads compared to their cell phones.
It doesn't matter. Sorry.
Go ahead.
It doesn't matter that there was no password protecting the contents in the iPad?
No, Your Honor. When this court decided the Smith case in 2009, many cell phones did not have the capability to have a passcode. So this was not a consideration this court gave in 2009, and it should not be a consideration that this court gives today. The consideration this court should give today is that iPads have more capabilities to transmit and store data than they did in 2009.
Did the police know that it had that capability when they examined it? Whether it could transmit or not? Some iPads don't if you don't have the service.
The evidence from this case does not suggest
Doesn't show
either
one
way.
way or the other.
Doesn't show one way or the other, Your Honor.
Thank you.
The 2 Smith exceptions of officer safety and preservation of evidence are absent today. The police had no evidence that this iPad was a weapon or any threat to the police. And there was no reason to believe the iPad contained any evidence that was at risk of destruction. And like in Smith, the risk to any evidence on this iPad to be destroyed disappears when seizing and turning off the device.
Counselor, was it reasonable for the police to assume that there was an opportunity to find evidence related to the crime on the iPad?
No, Your Honor. By the time the police had searched the the iPad. They had already interviewed Mr. Charleston and placed him under arrest. They knew what this situation was. They knew this was a shooting when Mr. Charleston returned home from school, and there was no evidence that this was premeditated in any way. So therefore, it would not be reasonable to assume that evidence would be contained on this iPad. And so nothing from this facts reasonably lead anybody to believe that either of these preservation of evidence or officer safety factors were present. So nothing prevented the police from approaching a neutral magistrate and receiving a search warrant after seizing the physical iPad.
Even though the iPad and the gun were very visible in the car.
Yes, Your Honor.
Could they have seized the gun without the search warrant?
Yes, Your Honor. The gun would be considered evidence of the crime, but this iPad could not be. That's the main difference between the gun and the iPad.
Even though the iPad was on?
Yes, Your Honor. There was no evidence that this iPad took any video or recorded any sounds or any of the incident that happened between Mr. Slater and Mr. Charleston.
But the police didn't know that at the time, correct?
That is correct, Your Honor. But nothing prevented them from going to a neutral magistrate. If they really did believe there was evidence on this iPad, nothing prevented them from going to a neutral magistrate in order to get a search warrant to search the device after they had seized the physical iPad to search the data on this iPad. Your Honors, I see that my time has expired. So for these reasons, we respectfully request that this court overrules the Court of Appeals, extends its Smith decision to the electronic tablets, and remand this case to trial court with instructions to suppress the evidence unconstitutionally taken from Mr. Charleston's iPad. Thank you.
Thank you. Counsel, please.
May I proceed?
Please.
Your Honors, before I begin, I would like to reintroduce myself. My name is Melinda Baer, and I will be addressing the second question before us, that of whether a failure to conduct a pretrial evidentiary hearing pursuant to a motion to dismiss under Revised Code 2999-32 constitutes prejudicial error. Mr. Chief Justice, may it please the Court.
Please.
The issue before us today is one of first impression for this Court. We have not had any experience with the statute. So therefore, our standard of review under a state of Heinzelman states that when a statute is clear and unambiguously worded, that the courts must rely on a plain meaning of the statute. Today I will show that not only did the appellate court not properly do that, they improperly relied on Florida law. They also misapplied and misinterpreted the Florida law. And this constitutes prejudicial error because they not only forced my client to undergo the burden of a trial and denied him the opportunity to argue his case under a lower standard, a mere preponderance of the evidence rather than beyond a reasonable doubt, but also because this error and the reasoning of the appellate court would mean that the statute has no meaning. Statute 2999-32 is commonly referred to as the stand your ground law, and it is very plainly worded to provide immunity from criminal prosecution in the case of the use of deadly force when in self-defense. The language specifically states that a person who uses force as permitted is justified in using such force and is immune from criminal prosecution for the use of such force. This language is clearly clear and unambiguous, and therefore Heinzelman should apply and would mean that the immunity would have to be established prior to forcing my client to go through a trial, as immunity is more than an opportunity to present your offense.
The Ohio statute does mirror the Florida statute in most aspects, correct?
It does, Your Honor.
And in fact, the one aspect where it clearly doesn't is the Florida statute mentions a pretrial hearing, and the Ohio statute does not.
Your Honor, while the Ohio statute does not specifically mention the pretrial hearing, it does include subsection B, which says that if a person who uses force fails to establish their immunity, then they are not immune. This means that they must have an opportunity to establish said immunity, or again, the statute would be meaningless.
But couldn't they establish it during trial?
Your Honor,
with a jury or the fact finder determining that the fear was reasonable?
Your Honor, with all due respect, that interpretation of the statute erases all meaning from the statute. If immunity only means that you have your opportunity to make your defense at trial, then the immunity itself is meaningless because you would have to undergo a trial in any event. And the purpose of the statute is to prevent my client or anyone else from having to undergo an unnecessary trial.
Counselor, what remedy would you have this court provide? For example, if we were to remand this to the trial court, wouldn't that put the defendant through yet more proceedings?
In this case, it's merely important to get the law correct, and my client is willing to undergo further litigation. And I would ask for relief that if you would remand this case to the trial court with instructions to conduct a full evidentiary hearing regarding my client's motion to dismiss. Your Honor, where the lower courts should have relied on a plain reading of the statute, they instead improperly relied on a Florida law which is similar, but which was unnecessary, given that the statute is clear and unambiguous. And even with this reliance on Dennis, they should have known that a pretrial evidentiary hearing was necessary, as Dennis held that. However, where the Supreme Court of Florida erred in Dennis, and where the appellate court erred in following them, was their judgment of this error as harmless error when it was clearly prejudicial. The Ohio Stand Your Ground law establishes a different standard for the evidence. A person must only prove by a mere preponderance, as opposed to reasonable doubt, that they acted in self-defense. That alone should be enough to constitute that prejudicial error by denying my client that opportunity. Furthermore, this destroys, the reasoning of the lower court would destroy the meaning of the statute by refusing to allow my client a chance to establish their immunity prior to trial. If you have to go through a trial to establish your immunity, then you are not immune, and the statute, again, is meaningless. It would be a gross error in statutory interpretation to allow this. It is a critical rule of statutory interpretation that you must work to enhance the meaning of the law rather than to destroy the meaning of the law. And for all these reasons, Your Honor, we respectfully request that you remand this case to a trial court with instructions to conduct a full evidentiary hearing regarding my client's motion to dismiss. Thank you.
I have one question on that. Does the appellant, if we rule, well, I'll ask this the other one. That's fine. I'll hold that. Thank you.
Thank you, Your Honors.
Appellees?
Before we begin, I'd like to introduce myself. I am Jessica Turner, and my co-counsel is Kushagra Mahaseth, and I'm here today on behalf of the Appellee of the State of Ohio. And good afternoon. May it please the Court. I will be specifically focusing on search and seizure and issues related to the Fourth Amendment. The lower court's decision to dismiss the appellant's motion to suppress was proper because in order to access evidence from a crime scene without a warrant, the police had to meet one of two exceptions. We get these two exceptions from Gant. In Gant v. Arizona, Gant was pulled over and because of having a suspended license, he was pulled out of the car, put under arrest, and taken into custody. Then when the police were checking his vehicle without a warrant, they found marijuana and a weapon. In Gant, because marijuana has nothing to do with the initial crime, they could not arrest him for having drugs. He filed a motion to suppress, and it was granted because it did not the weapon and the drugs did not pertain to the initial crime. This is why the two exceptions were made. The first exception is whether it's reasonable to believe that the arrestee might access the vehicle at the time of the search. Or the second exception that had to be met was if it was reasonable to believe that the evidence related to the crime might be in the vehicle. The first exception did not apply because Mr. Charleston was taken away from the car and put under arrest and had no time to return to the car after being put under arrest. Although the second exception did apply. The search of the car was done lawfully. We made these two exceptions to show that a car cannot be searched without a search warrant unless it meets one of these exceptions. It prevents the police from going through a car without a search warrant and taking evidence that does not relate to the crime and using it against them. In our case, the evidence that they found in the vehicle did relate to the initial crime. They found a gun and they found an iPad.
But, Counselor, what reasonable suspicion did the police officers have before seeing what was actually in the iPad to know that this was related to the crime?
Well, as you see, they had not found the murder weapon yet. They knew that a gun was shot in the crime, and they had not found the weapon. So because of how much the car played into the crime scene, how he went off into the car, drove away, came back, and then was pulled out of the car and then arrested, it would be reasonable to believe that evidence related to the crime might be in the car because of how much the car was accessed during this entire process.
Well, it's one thing to access the car and get the gun, but then they had to access the iPad, right?
Yes. Because of, the close proximity the iPad was to the gun, he could have put it in the trunk, he could have put it in a briefcase, he could have put it in a backpack, but it was right next to the gun, which...
The iPad was going to shoot the gun?
Well, because of the close proximity, you usually put things that you are using close together, which it would be reasonable to assume that they would be related because of the location of the iPad to the gun. It could have been showing that it was right next to him in the car, in the passenger seat, showing he might have accessed it because I put things in the passenger seat for easy access, whereas he could have put it in the trunk, in the back seat. The close proximity shows that it could have been obtained and while having, showing that it could have been related to the crime.
Could the officers have simply secured the iPad and then waited to get a warrant before actually searching through the iPad?
They could have, but because of timeliness issues, the iPad has the ability nowadays to be wiped clean of all information. Therefore, the information could have been destructed and not used. Because of timeliness issues and because they met one of the exceptions, it would be, because they met the exception, they're allowed to do it, and because of timeliness, it would be appropriate to do it in case of losing information.
But isn't timeliness a factor under the exigent circumstances analysis and not under the incident to the lawful arrest argument? And you just said that exigent circumstances weren't part of your argument.
Can you
Under
explain
Gant, you said there's two issues, right?
Yes.
One is you're afraid of destruction of the evidence or that they could harm the police,
Yes.
right? That's kind of exigent circumstances. And the other argument is information relating to the crime, right?
Yes,
Okay.
it is information. We're looking at timeliness in a different aspect.
Okay, tell me about that.
As in, not in a way that it could be harmful, or he did not have access to the iPad, but because it was not in a close proximity, which throws away the second, the first exception. But because it could be wiped or an iPad virus could be sent to the iPad through someone else, the iPad could be wiped clean, which deals with timeliness and the reason why they shouldn't have gotten a search warrant first.
Okay.
Counselor, I'm just not familiar with the record. Is there anything in the record that says that the police officers did anything to preserve the list that they found on the iPad? Did they take a picture of it? Did they take a screenshot of it after they discovered it on the iPad?
That was not explained in the brief. Thank you. So, as I said, the gun had not been found and the iPad had not been found. So it would be reasonable to search the car. The search also was not done extensively, unlike State v. Smith. The iPad was accessed, the document on the iPad was put in the easiest position possible to find it. It was like opening a book and it was laying right there in the open. Unlike in State v. Smith, where they've gone through extensive searches, they look through phone logs, all sorts of personal information to find the information that they needed to for the crime.
Counselor, in Smith, this court likened a cell phone to a laptop, correct? Now, a laptop could be opened and it's not locked, and there's a document on the desktop. What is the difference? And the laptop is protected, right?
Yes.
So what is the difference between that document on the unlocked laptop between the document found on the unlocked iPad?
Well, I think, there is a huge difference between how the access was accessed in the cell phone, whereas they went through extensive searches, they looked through the phone top to bottom, whereas with the iPad, it was laying right there. It was just like a piece of paper, as if a piece of paper was laying right there in front of him. And
well, presumably they had to turn on the iPad and flip through. I'm not that familiar with the record, but presumably it wasn't up already on the screen. Is that correct?
It was on the desktop, which if he wanted to hide the document, there are hundreds of ways he could have taken a way to hide the document. He could have put the iPad in a locked briefcase. He could have put the iPad in his trunk. He could have put in passwords on folders. He could have encrypted the document. None of these actions were taken. It was left right in the open as if it was just a piece of paper lying there, whereas the phone was gone through extensive searches so that it wasn't a search at all, and the access on the way the information on the iPad was obtained.
Counselor, I'm not sure that you answered my question, though.
Sorry.
I still don't see the difference between the document on the desktop of the unlocked laptop versus the document on the desktop of the unlocked iPad. If the document on the laptop is protected, which you agreed that it would be.
Whereas what I am trying to differentiate between what happened in Smith v. State and what happened in our case is the way the information was accessed. That's the difference that it holds, and the fact that
how many steps had to be taken, and
the search. It was not a search. It was laying right in front of them in the open. Whereas there are other precautions you could have taken on. The cell phone in State v. Smith was gone through extensive searching.
Continue.
Okay, thank you. So the second point I'd like to talk about is that appellant had no expectation of privacy. As I said earlier, there were thousands of ways you could have protected these documents. You could have put them in files on the iPad. You could have put in passwords on the files. You could have put in files on files. You could have locked it up in a briefcase or a backpack. You could have encrypted the document, and none of these actions were taken.
So the difference here is on the search is what the party searched did to protect its own privacy.
Exactly.
And is that the case law under Smith?
Excuse me?
Is that the case law under Smith, that a factor in determining whether it's a lawful search is the amount of protection, privacy protection, that the party whose device is searched, how much protective devices or numbers or passwords they put on the device? Is that the determining factor?
It's a...
Yeah, thank you.
It would be a factor of the case, more as what's State v. Smith ruled, as in this case, it shows that he had no expectation of privacy on the document.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. Before my time would begin, I would again like to reintroduce myself. My name is Kushagra Mahaset, and I also represent the Appellee in this case, the state of Ohio. And I'll be arguing the second assignment of error, but in this case, which deals with the stand your ground statute and the lower court's decision that the appellant did not meet the proper requirement to be entitled under the Ohio stand your ground statute. So So to understand the argument that the state is making, we'll be looking at two key factors. First of all, we'll be looking at whether the trial court's decision not to hold a pretrial hearing make the trial prejudicial to the appellant, Mr. Charleston. And secondly, we'll be looking at the facts of the case to understand whether he actually qualified for, or whether the decision made by the trial court that he did not qualify for immunity proper or not. So one of the key things that the appellant in this case today brought up regarding the lower court's decision not to hold a pretrial hearing was that they said it was prejudicial and it destroyed the whole law. And while we do concede that the trial court should have conducted a pretrial hearing, the fact that they did not conduct one does not simply make the trial prejudicial to the appellant or constitute a reason for this court to reverse the decision made by the trial court. That is because of three key reasons, and that is because of the one main reason, and that is that even though the trial court did not conduct a pretrial hearing, it was a simple harmless error. And to understand what that means what a harmless error means in similar circumstances in a standard ground case, we would have to look at the Supreme Court of Florida case of Dennis v. State to understand it, and that is because a plain reading in this case is not unambiguous, because nowhere in the statute does it say that a pretrial hearing should be conducted. So therefore,
but Counselor, if I read the statute and it says if I prove certain things by a preponderance of the evidence, I'm immune from prosecution, how do I successfully make the case I need to make under the stand your ground statute without being subject to prosecution?
Well, yeah, that's the thing. That's the problem with the problem with the ambiguous language in this law is that it does not say what the court should do to determine that. It does not specifically say that a pretrial hearing should be conducted, or it does not say where or how the courts can determine that. So the best way to determine that. So the best way to understand that would be to look at Dennis v. State. And there are three reasons why Dennis v. State properly applies to this case. First of all, the Ohio standard ground law mirrors the Florida standard ground statute. Secondly, this is a case of first impression, and this is the best case. Dennis v. State is the best case that we can look at. And finally, the procedural history of Dennis v. State is very similar to the procedural history of this case at hand today. So, first of all, in Dennis v. State, the defendant, Mr. Dennis, was charged for murder, and he filed for a motion to dismiss, and a pretrial hearing was not conducted by the trial court. Once the case reached the Supreme Court of Florida, what the Supreme Court of Florida ruled was that while they agreed that the trial court should have conducted a pretrial hearing, they also said that just because they did not do that does not result in immediate disqualification of either the decision made by the trial court, because they said that it wasn't harmless error, i.e. that error did not lead to either the conviction or the verdict in that case.
Well, tell us why in this case, if no hearing was held, why it was harmless.
Well, first of all, the appellant does not indicate that he would have presented any different evidence or any different testimonies or any different witnesses compared to what he presented in his actual trial. But the second the more important fact is that it was a bench trial and not a jury trial. So because the person who was actually judging the evidences regarding the immunity and the prosecution was a judge, he could easily distinguish the evidence that relates to his immunity, and and passed down judgment based on that. And
did the trial court consider the stand your ground issue as an immunity issue or a mitigating factor in terms of sentencing?
In this case, it was considered as a mitigating factor.
And so, help me to understand then why that is sufficient with regard to the statute's immunity provisions.
Well, because even if we go back, and even if a pretrial hearing was conducted in that case, then the court would have come to the same decision that he did not qualify for immunity, because he does not, the appellant, Mr. Charleston, does not indicate that he would have presented different evidences. So even if a pretrial hearing was conducted, the outcome would not have changed.
But Counselor, what if, so say the appellant makes the case he can under the stand your ground statute, and it mitigates his sentencing, and he gets the best possible sentence he can, as a result of the case he made under the stand your ground statute.
Yes.
The best he can get in that situation is a low criminal sentence, whatever that sentence is, jail time, fine, whatever. The best he can get with that same case at a pretrial hearing would be no criminal prosecution, right?
Yes, Your Honor.
So how was the appellant not, how is that harmless?
Well, Your Honor, so if let's assume that a pretrial hearing was conducted, then he would not have presented any different evidence. So the judge would have come to the same decision that he came to at the end of the trial, that he wasn't, that the stand your ground law did not help him get the immunity. So he would not have, the outcome would have still been the same. So in this case, that's why, while this was an error, it was a harmless error that would not have changed the outcome.
Well, let me ask this. At trial, wasn't the standard with the court beyond a reasonable doubt?
Yes, Your Honor.
And that the stand your ground would only be have to be proved by preponderance of evidence at a hearing?
Yes, Your Honor.
And isn't that a huge difference?
Yes, Your Honor. But the thing is that when the judge is looking in this trial, when the judge looked at the evidence that could have proved his immunity under the statute, he would have been able to distinguish that he would have been able to identify that the evidence that would relate to his immunity would only qualify for, would only need to reach the burden of preponderance of evidence. And that might have been an issue if the trial court was a jury trial, but since it was a bench trial and the person who was deciding was a legal expert, a judge who are trained to do these things, that's why it did not really alter his rights or make the trial prejudicial to him. Now, if we look at the case of the facts today, or the case of the statements of the case, or facts of the case, to understand if the trial court reached its decision to not give him immunity properly. So the law, the stand your ground law, or revised code 2999.16, states that a person is allowed to use deadly force when he has reasonable belief that such force is required to prevent imminent death or great bodily harm to himself or herself. Now, in this case, was there an imminent? Was there a threat? Was the defendant facing or appellant facing imminent death or great bodily harm? The facts of the case would show that he did not, because Mr. Charleston had, when he came out of the car, he had the time to pull out his gun, retrieve his gun, pull it out, and warn the victim, Mr. Slater. So it wasn't imminent death. Secondly, at no point did Mr. Slater pose any threat to him. He was wearing a ski mask and carrying a shovel, but we have to remember that it was a cold December night and it was very snowy. So it is reasonable to believe that he was his attire was reasonable because of the given circumstances. And when Mr. Charleston asked him to stop, the victim, Mr. Slater, did try to stop. Now, given the slippery condition or the snowy condition of that night, he slipped and he tried to regain his balance. Now, that balance, that attempt to flay his arms and regain his balance was seen by Mr. Charleston as an attempt to attack, which is unreasonable because the motion of flaying someone's arm and motion to attack is certainly very different. And then, so it was unreasonable for Mr. Charleston to believe that he was threatened, and that's why the trial court properly reached its decision that he did not qualify for immunity under the statute, which said that he needed to have reasonable belief that such force was required to prevent imminent death or a great bodily harm to himself. So that's why the trial court's decision not to hold a pretrial hearing, because of the reasons I gave before, were a harmless error that did not prejudice the trial or constitute a reason for this court to reverse the decision made by the trial court. And secondly, the facts of the case show that the defendant was not entitled to immunity under the language of the law. So that's why this court should, that's why the decision of the trial court was proper, and this court should affirm the decision made by the trial court. And this court should also affirm the decision made by the trial court regarding the motion to suppress the evidence. Thank you.
Thank you.
Thank you.
Any rebuttal?
Yes, Your Honor.
Please.
May I proceed, Your Honor?
Sure.
Mr. Chief Justice, may it please the court. Your Honors, I have 3 points I'd like to make today in rebuttal. First, the state contends that the search of the iPad required little intrusion. However, this is incorrect. When the police picked up the iPad, they had to press the top button to illuminate the screen. Next, they had to slide their fingers across the screen in order to open the actual iPad. And then they had to rifle through the list of documents and applications that Mr. Charleston has on his iPad and choose which ones to look at. This required much more intrusion than the state contends was really present. And in addition, the iPad is an effect. This court ruled in State v. Smith that the cell phone is an effect of a person, not a paper. Likewise, the iPad is an effect and not a paper. Second, the state contends that it was reasonable for the police to search Mr. Charleston's iPad. However, when the police found the iPad, it was located on the floorboard of the passenger side seat, where it could not have captured any video or any audio of the incident. Nothing from these facts contribute to any belief that this iPad contained any evidence of the incident between Mr. Charleston and Mr. Slater. The state also contends that the search of Mr. Charleston's car allows a search of the iPad. However, the iPad is a separate container in the car. In order to open this container, the police would have to have a suspicion that the iPad contained evidence of the incident. And we've already proven that this is not true. The police had no evidence that this iPad was in any way related to the death of Mr. Slater. And just because the gun was in close proximity to the iPad does not signal that they are related. The iPad was found on the floorboard. Mr. Charleston, coming back from a day of school, could in all likelihood just placed it there, hoping to pick it out easily when he gets home.
Didn't the police find at least what they characterize as a hit list on the iPad? And doesn't that indicate that it was related to the
They did find what they categorized as a hit list, Your Honor. However, they had no knowledge of this hit list prior to searching the iPad. The Fourth Amendment protects against unreasonable searches and seizures, and just because this iPad was later found to contain evidence does not make the unreasonable search legal.
If we reverse the judgment, do you want your client to get in a new trial?
We would like, yes, Your Honor, this evidence was clearly contributed to Mr. Charleston's conviction. The police presented and categorized this list as a hit list, which made Mr. Charleston's act seem premeditated. However, Mr. Charleston's act was not premeditated, and therefore this evidence was clearly used to prejudice Mr. Charleston at trial. My third point I'd like to make, Your Honors, is that the state argues that immunity from prosecution can be established at a criminal trial. However, immunity is an entitlement not to stand trial or face the burdens of litigation. And Mr. Charleston's claim to immunity was effectively lost because his case was erroneously permitted to go to trial. This injustice can now not be redressed because Mr. Charleston has already been forced to face trial, face prosecution, and was not granted immunity for the charges against him. Therefore, the error of not conducting a pretrial evidentiary hearing is completely harmful and prejudicial to Mr. Charleston, because this error cannot be effectively redressed.
How do we deal, though, with the fact that the Ohio legislature didn't include the Florida provision for a pretrial hearing? I mean, statutory interpretation would say if you leave something out, you meant to do it in the wisdom of the General Assembly.
Yes, Your Honor. Ohio's statute provides that the immunity be established, that a defendant must establish his or her immunity from prosecution. So therefore, this must take place before trial because the prosecution would be the trial itself. So therefore, it must be established through a pretrial evidentiary hearing.
Well, but wasn't the defendant given an opportunity to present evidence with regard to the stand your ground issue at trial?
Yes, Your Honor, but he still had to face the prosecution of a trial and litigation, and this can now not properly be redressed. And for these reasons, Your Honor, we respectfully request that this court reverse the Court of Appeals and remand this case to trial court with instructions to suppress the evidence unconstitutionally taken from Mr. Charleston's iPad and with instructions to conduct a pretrial evidentiary hearing concerning his motion to dismiss. Thank you.
Counsel. The Scoring judges will now leave. At least you're done with the first round. You can relax a little bit. You've got some experience under your belts. I do want to emphasize that what Judge Klatt said is true. What you saw today, what you felt today, is what lawyers go through every day in the appellate courtrooms of the United States. So you got a very good attempt to recreate that for you. And I want to say, the timekeeper, you did the right thing, but when a judge asks a question, even if it's at the end of their time, generally the courts let them answer. No, it's okay. Because what happens in the real courtroom is a red light goes off. And in the Second Circuit in New York City, you need to stop, and then the court will say, continue your answer. Other courts just let you finish the answer, so it doesn't matter. But the judges are going to give you some general comments.
You all were phenomenal. You all four of you did a very good job. It's very obvious that you all know the law and the facts very well for this case, and it's a lot of work, and I commend all four of you for that. Job well done. It's just a few notes that I took during your arguments. I kind of noticed you guys had a little bit of a cold bench, and you guys had a very hot bench. That means you didn't get many questions. You got all kinds of questions. And you both handled it. It can be equally as nerve-wracking to stand there and talk and talk and talk and wonder who and when and if they're even going to ask you a question. Are they listening to you? Nothing. And you, and especially you, Jessica, got grilled. And you, and I, especially by me. And I think at one point we were talking, you got questions thrown at you from all three of us at once, and you handled it wonderfully. You didn't let it rattle you. You had, you stuck to your guns and you made your argument, and you handled it as well as you could. What else do I have? All four of you had very good roadmaps for your arguments, which is very helpful. Evan, at one point, it took you about 2 minutes to actually get to your roadmap, and that's
I wrote
something.
actually 2 minutes and 30 seconds, but yeah.
And Judge Fisher can speak to that more than I can, but it's very helpful to know what your argument is as soon as possible. What else can I say? At one point, Jessica, and this is something that in the training that I've done for these competitions in law school, you mentioned you wanted to focus on one exception in Gantt, I think, as opposed to the other one. The other one you said it didn't exist or it didn't apply. That wasn't at issue here, whatever. For sake of time in making the argument that you want to make, just say there's two exceptions. Only one of them applies here. And if a judge asks you about the other exception, be ready to answer about it. But don't waste time talking about an exception that doesn't really apply. Yeah, that's it. You guys, all four of you did a very good job. You should be proud.
Yeah, definitely very well done. I'll echo my colleagues' comments that it was really obvious that you guys prepared, and so for me, especially when we started asking questions, for the most part, it seemed like you guys had sort of anticipated what some of the weaknesses were in your own cases and had answers ready for those issues, and that's kind of what we want to see. When judges ask questions, usually it's a good indication of where they're struggling. So if I want to side with, one side or the other, those are the issues where when you're imagining writing it, that's where you're sort of, well, how am I going to write around that issue? And so that's what they're looking for from the answers, and I thought for the most part you guys did a really nice job with that. On the timing issue with the roadmap, and so maybe I'll let Judge Fisher speak to this more than I can, but typically on the appellate level, you don't need that much as far as facts go at the beginning, simply because we've read the briefs and the facts are really more a trial level issue. And so I understand you want to tell the story, but at the same time, you've only got, what, 7.5 minutes for that? And so, kind of getting to the argument a little quicker is not a bad thing. And kind of same thing on the timing issue. And you guys don't need to hit every single point that you would hit in your briefs for an oral argument. If you're going to try to hit 6 or 7 different things, that's going to be awfully hard to do. So on petitioner's side, right, you typically would put your strongest argument like up front, right? And on respondents, you get a little bit of a choice of, do I want to rebut first or do I want to put my own? But if you're going to try to hit all 6, 7, 8 different things, you're just going to run out of time. 7.5 minutes sounds like a long time maybe, but definitely not. So, but yeah, really nice job overall, guys.
I was very impressed. If you become lawyers, you'll be great lawyers, I think. And if you don't, your ability, all 4 of you, to answer questions while standing there is very important. Even if you're in business, you'll be at a meeting with a group in your company, and you're doing a PowerPoint presentation or something, and the boss is asking you questions, and you got to be able to answer on your feet. And it's just a good ability to learn, and it's something that can be learned. Some people think that it's natural. Well, for some people it is. But I can tell you, I've done very well in my life on appellate arguments, and I was as scared as you guys were, okay, to start out. But I learned. It is a skill that can be developed. It's not an inherent ability. And you all, whether you inherited it or developed it, did very good job. On the facts, John is right about the facts. You don't have to use that much. A paragraph or 2 of the facts, just to kind of lay it out to get you started. But after that, just go on. Although when you got to your roadmap, it was very well done. I mean, you should be proud. I mean, all of you laid it out. And for a court of appeals, sometimes somebody will lay out 3 or 4 issues that they're going to talk about, and we'll even say, well, skip 1 and 2. Let's just get to number 3, because that's really what we're thinking about. But to lay it out there is a good way for the judges to know what you're thinking and where you're going. And I know we got a little bit down on you with a lot of questions, but it does happen. I'll be honest with you. In appellate arguments where one side doesn't get any questions, the other side gets pounded, and it doesn't tell you anything about what the court's going to decide. It just has to do with what's interesting to the judges, to be honest with you. So don't think about that. The other thing I told the one group, and I think it's true, you all did a much better job than sometimes I see lawyers at oral argument deny the undeniable. And to be honest, you lose credibility in your argument. Accept the negatives, but work around them. Judge, that's correct. The gun was found within a foot or 2 of the iPad, but that's not important in this case. Why? I forget who talked about it, but that's good. That's a good way to do that, to deal with that. And because if you deny the undeniable, then people don't trust what you're saying for the rest of your 7 minutes or 10 minutes, whatever. So that's important. And I want to say, each of you stood there up and you had a great voice. And I'm not saying voice and that you're going to be on the radio, okay. I meant voice from your soul about how you felt about the case. And that is conveyed to us. We can feel that. And that's important, whether you're in court or you're in a presentation at the office, or you're working for a nonprofit and you're asking a group of people to donate money. That confidence is so important to convey that you believe in what you're saying. Because sometimes people get up there and you can tell they don't really believe what they're arguing. And that hurts your argument. So I thought all 4 of you did great. I think you're all going to be successes later in life, and that's really important. And I'm so glad you're participating in this program.
Thank you.
Thank you.
Well
Nice
done.
job.
Thank you.